It's good to see a lot of familiar faces, a lot of new faces, and I'm very happy that you were able to spend your afternoon here to discuss the ever more important question of self-regulation on the internet. My name is Marietje Schaake. I'm a member of the European Parliament for the Alliance of Liberals and Democrats for Europe from the Netherlands with D66 political party, and I deal with issues relating to Europe's digital agenda, especially intellectual property rights issues, net neutrality, but also with international trade and foreign affairs. But we're not necessarily talking about that today, although the standards that we set ourselves do have a significant impact on our credibility in the world. We're going to have an afternoon with two panels. One will give the sort of institutional view, where we're very happy to have two guests from the European Commission. Werner Steng will speak with us first. We'll introduce his ideas. He is the head of unit of online services of DG Markt. And Nicole de Wandre is with DG Information Society and Media, where she is a counselor of stakeholders issues. So I think the two are very well positioned to give different perspectives from the European Commission side, and then we'll have a discussion on what they've introduced. And then at around 4, but we're a little bit late, let's say 4:15, we'll have a new panel which I'll introduce then. And the reason why I wanted to invite you all to take part in this discussion is that there's a number of subjects where the question of who gets to make the final decisions on what happens on the internet becomes relevant. It's relevant when it comes to illegal content, whether it is the discussion about child pornography or violence or terrorism-related issues, all the way to what could be hate speech, and recently highlighted also by the European Court of Justice verdict, how to deal with intellectual property rights infringement, so-called piracy discussions, and what is an effective way to deal with it. There's a big push, I would say, for multi-stakeholder initiatives in a number of angles of internet governance, including when it comes to dealing with illegal or inappropriate content. And for us, as members of European Parliament, people who seek to deal with lawmaking and policy making, and as democratically elected officials, the question is, of course, who has the ultimate responsibility? And how do we preserve a separation of powers in a democratic society? Where does democratic oversight come in? And how do we ensure that people's fundamental rights are preserved? And so in that sort of context, I look forward to the discussion this afternoon. So I would now like to give the floor to Werner, and I also encourage you all to be active in the discussion, so save your questions, and there will be plenty of time for that. Werner, please go ahead.
Thank you, Madam Chair, and good afternoon, everybody. I think you are manipulating the slides, Ben, so if it could just have the first slide, please. Oh, it's up there. Sorry, I thought I would see it in front of me, which I don't. All right, so I'm Werner Steng, Head of Unit for Postal and Online Services in DG Markt. I'm very grateful for Madam Schaake to have organized this event, because the topic is extremely important also for us. And as you all know, lots of things are going on in this area. A lot of national activities, a lot of court rulings all over the place. So I'm grateful for any opportunity to obtain more feedback and views on this important topic. Now, while the heading or the title of this conference is self-regulation, as you can expect from a good Commission official, I will more focus on regulation, namely that part of regulation that I am in charge of and that has something to say on this issue, which is the e-commerce directive. So what I'm going to do in my short presentation is, first of all, to repeat a bit what the e-commerce communication has to say on this. Secondly, assess to what extent it works, given its policy objectives. And thirdly, what we intend to do on this subject matter in the months to come. Next slide, please. Yeah. So first of all, the e-commerce directive, as most of you certainly know, contains several articles on the so-called liability regime. The objective is at least twofold. I mean, there are sometimes conflicting interests to be reconciled. We clearly want the internal market for information society services to work, and the whole e-commerce directive is meant to facilitate that. But equally important, there are also lots of other interests and fundamental rights and different fundamental rights that are affected as well. The e-commerce directive, as well as the liability regime contained in it, is horizontal in nature and scope. So it is not restricted to a specific type of illegal content. So, but whatever the reason may be for this illegality, the regime applies. So in that sense, it covers anything from IPR infringements down to child abuse, terrorism, hatred, and so on and so forth. It covers different scenarios and different types of services, mere conduit, caching, hosting. The most important articles are clearly the ones that I put on my slide, Article 14 and 15. Most of you, again, will know that. Article 14 clearly spells out that the hosting intermediary is not liable for illegal content if he doesn't have actual knowledge of such content. But once he obtains such knowledge, he has to act expeditiously to remove or to disable access to it. That's the correct language. That is, by the way, also why on my first slide you may have noticed I was having notice and action rather than what is commonly referred to as notice and takedown, because there's not only takedown that is foreseen here, but also the blocking, disabling access to it. So that is all pretty clear as a general principle, but not when it comes to interpreting it and applying it on the ground, as we will see in a minute. Article 15, at least equally important, says that member states may not impose on online intermediaries a general obligation to monitor the content they transmit or host. Once again, very good principle, and also once again has been interpreted quite differently by many players. Some other stuff, obviously, in that directive that is relevant. To give just two examples, first of all, there's also a clear acknowledgement in the directive, in its recital 46, that whenever such action is taken, removal or disabling of access, the principle of the freedom of expression has to be observed. And also, and that's at least some link to this self-regulation theme here, there's also an encouragement in that directive, in its Article 16, that codes of conduct should be drawn up. Not much has happened here, I'm afraid, but anyway, there is this link in the directive as well. Now, that's where the directive more or less stops in terms of guidance and rules. And as you all know, there has been many different interpretations across member states. There have been different court rulings at national level, but also at ECJ level. And we have had some recent case law here, and I've just put up some examples here on what that case law said in very simplified language. The first issue here is when and how do you obtain actual knowledge according to the court? And there are there's different guidance that came out of those court rulings. Already, I have to say that none of these rulings has exhaustively interpreted these articles. Yeah? So we still don't have clear-cut rules on all the terms and concepts introduced by our directive, but there's at least some indication. So you could obtain knowledge if your role is not, and that's from the Google LVMH case, not merely technical, automatic, or passive. In the case of Google, that referred, for instance, to the drafting of the commercial message which accompanied the advertisement link, or it was the establishment or selection of keywords. So there's some additional information on what, in that particular case, active role meant. There's also something, obviously, in the L'Oreal eBay case, where they said that eBay was active to the extent that it optimized the presentations of the offers for sale or promoted these offers. So, but this is just case-by-case interpretation that gives some ideas, but obviously it does not give the final answer. Secondly, you can also obtain actual knowledge by means of an own initiative or by means of notification. Own initiative obviously means that if the intermediaries do something on their website and find such content, then it has obtained actual knowledge. That's fairly obvious. The notification is also clear. The only additional guidance here was that such notification has to be sufficiently precise and substantiated. Again, you could then take each of those words and try to put more meaning on this. As regards injunctions and Article 15, it clearly said in the L'Oréal eBay case that a court may oblige an intermediary to take measures that puts an end to IPR infringements. It was an IPR case, but also to prevent further infringements. And the second quote here from the very, very recent Scarlett Sabam ruling said that a court may not oblige an intermediary to install a general filter to avoid certain IPR infringements. So that was very much in line with the whole purpose of Article 15. But again, we're in this discussion now of what is general, what is specific, how specific does it have to be, and so on and so forth. But in any event, these were some important cases that will help us in further debates. Now, when we did a public consultation on the e-commerce directive, but on e-commerce more largely speaking last year, we got lots of replies to this consultation. We had some 420 replies, 5,000 pages of text. And as part of the questions obviously related to this liability regime, and there was a lot of feedback on that. Generally speaking, for the whole directive as well as for the liability regime, most people felt that we should not change these rules, that the e-commerce directive, generally speaking, had been very, very useful in the development of online services and e-commerce in Europe, has been an enabling factor. And also the liability regime, the principles have proven have kept their value, but there may be need for clarification because, as indicated before, there's been a lot of divergent use and rulings on these provisions. Most specifically, the criticism was that where indeed content was illegal and should have been taken down, such takedown had been too slow or had not taken place. The second group of complaints was that rules are so fragmented across Europe that this has reduced legal certainty for economic actors or for anybody involved in this, has therefore also increased compliance costs for internet service providers and so on. And the third group of concern was in the area of civil rights, in that the directive, or at least interpretation that has been given, has created some incentive to take down content, even if such content is legal, that sometimes an ISP, in order to avoid trouble, if in doubt, takes down the content. Second, that there are no or not sufficient or not sufficiently fair appeals procedures for those whose content has been taken down, and generally speaking, a lack of transparency of how all of this is done and operated, and who does what, and so on and so forth. Now, based on this large consultation and a lot of other things we've been doing, we have prepared a communication on e-commerce and online services that is currently being translated and will be adopted, hopefully, by the European Commission on the 11th of January next year. that's a broader issue, obviously, than liability. So we're looking into many different things that are relevant to e-commerce. But one of the issues is the liability regime, where in the staff working paper that is attached to the communication, there's a detailed description of the status quo, so what we have found, what's going on out there, what has been brought to our attention. And then we announce an initiative on notice and action based on the directive. So because one of the main conclusions of our communication is, by the way, that the e-commerce directive will not be changed. So that also means that all the articles linked to the liability regime will stay there as well as they are, but that we will look into the procedures that are needed to implement those principles. So we will examine how these procedures are carried out in the real world, and to see whether there is any good practice that can be taken as a general guidance on how such a process could be carried out that would respect all the principal values that you may expect here. And definitely, I'm not just talking about the economic rationale here and interests, but very much all the fundamental rights and freedoms that are concerned by this. So that is ongoing work. We have no idea yet on what the outcome will be, which is good. We have not we don't have any political guidance or instructions that would push us in one direction or the other. We can really sit down, discuss, examine, and then see whether and what can be, so whether something can be done and what can be done in order to bring more clarity and certainty into this highly sensitive area. So that's where we are. We are, last bullet point here, at the stage of collecting input from everybody who has something to say on this, which is once again why I'm very grateful for having been invited here and to have a chance to listen to all of you here and hopefully provide some answers as well. Thank you very much.
Thanks for your introduction. We're going to go straight on with Ms. Dewan.
Thank you. Yes, thank you very much for this opportunity to share with you the views of Nelly Kroes and the Directorate General Information Society and Media on self-governance in the domain of the Internet. I want to, yes, that can just first anchor the few remarks in noting that the self-regulations comes from the 2001 White Paper on European Governance, where we notice that the representation mode of policy making and law didn't manage to take into account new trends, globalization, the problem of sanitary things, a lot of issues where other stakeholders needed to be involved. This not meaning that the system was not good, but just that we had to, in a resilient mode, so to speak, see how in the policy making we involve other actors in an inclusive way. So I think that this is really where the self and co-regulation processes come from and should be looked at in that global perspective of completion, and I will explain that a little bit more. The last event, the last document that the Commission adopted on corporate social responsibility to give a new momentum to the corporate social responsibility policy, a communication was adopted in October. This is the last bullet on the slide there. And in that communication, there are two actions particularly on which I want to draw your attention. The one is the next slide, please. Sorry. The first action in that communication on corporate social responsibility, it says that the Commission intends to create multi-stakeholder CSR platforms in a number of relevant industrial sectors, for enterprise, their workers, other stakeholders to make public commitments on the CSR issues relevant to each sector and jointly monitor progress. I want to inform you that we want, DG INFSO wants internet to be one of these sectors, one of these relevant industrial sectors, so that we will create one multi-stakeholder platform in this area. The next slide shows you the second action where INFSO will play a particular role. And this is the linkages between self and co-regulation processes and corporate social responsibility. Because in this communication, we state that it is part of what is expected from corporations for demonstrating corporate social responsible behavior to engage in self and co-regulation processes with a certain ethics and respecting basic principles. So we would like to launch a process, we will launch a process in 2012 with enterprise and other stakeholders to develop a code of good practice for self and co-regulation exercise. So this to really set standards, basic expectation, design principles, to make sure that self and co-regulation processes, when they take place, are not an easy way out of making engagement behind closed doors and with no accountability. We want this process, when they happen and that they are really up to standard. So the next slide will show you what we expect as good practice, but of course this needs to be validated by the process that is announced in the communication. We think that good practice in self and co-regulation is when the stakeholders, the process is open from the start. That is, that all stakeholders and not only the corporation that will take the commitment are around the table, that the process is transparent, that where there is a possibility, notably by virtual debate and ICT-based tool, to engage in the process. The sincerity means that we have to agree on the common goals and not play around, if possible, and really be frank and agree with all stakeholders on the concept and the goal of the measures and the codes of conduct that will be approved. Monitoring will need to be put in place by independent bodies so that the society can rely on this monitoring. Of course, compliance should be sought, and if repeat offense, sanctions should be foreseen. So that with this kind of good practice, we think that self and co-regulation are really, next slide, we are there, yeah, are to be seen as complementary to the other forms of policy making, and in particular lawmaking. Because the complementarity plays at different levels. First, that there is law act, the possibility to take regulatory action if the self and co-regulation processes do not deliver is always there, the sort of back stick argument. Of course, self and co-regulation, as mentioned in the interinstitutional agreements, has to be not only compliant with existing legislation, but also should not substitute to area where it's better to act by law than by self and co-regulation. So that complementarity is really a key feature of self and co-regulation when they take place. The second thing is I think that self and co-regulation processes allow to really take into account the increased complexity. Each of us has a different way to define what complexity means, but I think we can admit that basically it means that any command and control model is, as soon as it is set, it is already dépassé or out, how should I say, I'm sorry, that as soon as you set something in place, the feedback effects are so quick that it's very difficult to know, to have the expected impact only happen, and that you have a lot more things, feedback effect coming in. So that, in fact, the law, we have seen with the case law the importance of case law for also understanding of the rule and what it means to respect the rule. And I think that in the same way, we must also take advantage of the capital of reputation for the corporation and the public opinion, and that there can also be a pressure through these modes of if we manage to get through self-regulation good behavior, as we all expect in a transparent way, this is an additional way to sort of act on the system through indeed reputation and public opinion. So this complexity, this is what I mean by expansion of public sphere and debate, is not to rely that only the parliamentarians will do the job and then the judge, and that the company will pay a fine if they don't comply. No, I think indeed we all have a civil society to stay on the ball all the time and also exert the pressure of the public opinion and the public debate beyond these more formal judiciary channels. So. Of course, internet and the digital transition at large really are an area, a playing ground where self and co-regulation have a great role, because the complexity, it impacts society in such complex way and in such profound ways that I think we are in one of these areas where really nobody can predict exactly what is the exact impact of one measure, and we all have to be resilient and adaptive. We are really in a transition management mode. So next, please. This being said, I want to restate here Internet essentials, as Nelly Cruz has called them, in a speech that she did at the high-level meeting on the Internet economy at the OECD in June last, before the summer, where she has put forward 6 essentials. The first one is, let's keep one Internet, and here I want to quote, so she said, Internet's most important characteristics is its universality. The second essential is that we are people and not atoms, nor packets to be switched. So Internet is really not just a technological platform, but a forum where people interact. And with that, I want to say that she's fully aware of the importance of Internet on people's life, and we all, of course, keep this in mind all the time. The third essential is architecture. Architecture matters. And she says that the current architecture of the Internet is fundamental to its dynamic, socially, politically, legally, and economically. So that is really full recognition and support to the generative nature of Internet. She also said that we need to have a broad, structured, and coherent debate with Internet policy and research communities on the impact of any change in architecture. The fourth essential she puts forward is that barriers to trust are barriers to access. So indeed, reliability, confidence has to be strong on the Internet. The fifth one is to make Internet a pro-democracy tool. And with that, also acknowledging that we need to support bottom-up approach to problem solving so that citizens can co-create solutions. The sixth essential is, let's make the Internet a multi-stakeholder and transparent tool, where recognizing also that institutions of democracies have duties towards citizens to maintain Internet as such. So these are strong engagements and sharing of vision of what is essential to the nature of Internet for our commissioner. So in the self-governance area, there are 2 plays now. Yes, the next one. In small letters is a speech reference that you can find. So on the do not track strategy, she has called in a speech in June in Brussels, she has called for do not track standards to be adopted by the Internet industry and the online behavioral advertising industry, and she expects results by June 2012. Another area where we are practicing self-regulation for the moment is Better Internet for Kids, where last week a coalition of 28 major companies in the Internet, this is, yes, the next one, has adopted to engage in an exercise with 5 goals to make progress, to make simple and robust reporting tools, to make wider use of to have age-appropriate default privacy settings, to make a wider use of content classification, wider availability and use of parental control, and effective takedown of child abuse material. Now, upcoming, this Friday, at the conference Freedom Online that takes place in The Hague tomorrow and Friday, where Hillary Clinton, I think, speaks tomorrow. So Nelly Cruz will make an address. And also on Monday, there is a joint announcement to be made by her with Vice President High Representative Ashton on this Monday. So I just encourage you to pay attention to these two events where she will speak. So with this, in conclusion, I really want to say again that we have a twin engagement. First, for a universal and generative vision of the internet, and second, for an inclusive policy making, to really engage into an inclusive policy making, away from seeing self-regulation as an opposition or to another mode of lawmaking that would be wrong or broken. Not at all. We really want to take the best out of these two ways of making policy in the sense that society expects and deliver societal goods. And with that, I will also, as my colleague mentioned, that I'm very thankful you organize this, because we are here to listen now that we have said what we have to say. Thank you.
Thank you very much. I can already feel a lot of questions coming up, and I'm going to actually make use of the benefit of chairing this meeting by asking two questions myself to begin with. What fascinates me, first, for Mr. Steng, a question. When you mentioned that a company is not liable when it doesn't know what content might be on its platform or whatever, which could be illegal. And that leads me to the question of where is actually the source or the stimulus for addressing issues in the context of self-regulation or co-regulation. It sounds even friendlier. Because we know that there's a real interest from certain industries, for example, and there's a disproportionate power sometimes. So some industries might have a real interest in taking certain content down. They may have lawyer teams who are doing nothing but reporting content. And thereby perhaps this window of not knowing what content it is about is very, very small. But also the direction or the responsibility put in the hands of certain players can be quite disproportionate. So I'm curious about that. Actually, we're looking here in Europe at some impacts that could be foreseen when we're also looking at the United States, where two bills, when it comes to self-regulation in light of intellectual property rights, are under debate. One is called the Stop Online Piracy Act. The other is called Protect Intellectual Property Rights Act, which could even go as far as having websites taken down that are hosted elsewhere in the world. So basically, how far can this go? And my general question, I guess, for both of you, but I'll direct it especially at Ms. De Wanderen, because she mentioned those principles of an open internet, which I think are very important. The notion of one internet, which clearly this extraterritorial impact would break. So how to prevent that, and also how to make sure that law enforcement, which is traditionally in the hands of government, isn't outsourced, isn't privatized to an extent that it has a serious impact on internet users. So thank you, and then I'll start looking around for questions.
Yeah, it's a difficult question, obviously. The directive, as I presented it or reiterated it to those who know it already, is deliberately limited itself to establishing some general principles and sort of things that we want. And then we have to see how we can best obtain those results. And the purpose clearly is, if you read those articles, number one, as I said at the beginning, that we want the internal market for information society services, and we don't want any artificial obstacles to that. So in principle, we would not want to impose any burdensome obligations on internet service providers. And that is reflected in Article 15 and so on and so forth, but already in this general exemption, Article 14. On the other hand, what we also want, of course, is that if there is illegal content, that illegal content disappears. I mean, that's also as much in the interest of society as is the legitimate request for having a free internet. Now there is many different ways between black and white, and many stakeholders have taken different views on this, where to draw the line. It is obvious that some forms of illegal content have stronger economic interests behind them. Yeah, so that's, I mean, we all know that we're talking about IPR infringements here, because there's a very strong economic interest driving the agenda in a certain direction. The clear-cut answer there is one of proportionality, and if you carefully read, and I'm sure all of you have done that, if you carefully read the Scarlett Subban ruling of the court earlier this month, no, we're already in December, it was in November, it's all about proportionality and striking the right balance. And that is precisely what we are after also in our deliberations here. Now, to what extent can self-regulation work? I mean, as a starting point, I would always be in favor of lighter regimes. There is no doubt about that. If there is self-regulation that helps us to achieve our objectives, but that would also mean that, as you said, the IPR industry is equally happy with the results obtained, then all is fine. Yeah? But if we see that we cannot strike that balance that needs to be struck, then we need to consider what else can be done. So as a first instance, self-regulation is great, but we have to monitor it, we have to see whether it helps us reach our policy objectives, and if not, we need to think about a plan B. In terms of international access or international, of course the international dimension we will have to look at as well, because it's obvious that we have, that the e-commerce directive applies within the 27 member states. What can be done if content is hosted elsewhere? We have no answer to this yet, but it's obviously part of our considerations.
Yes, on the law enforcement, how to avoid it to be externalized, I think it's very clear that self and co-regulation, and by the way, I think that in fact self-regulation, when we speak about self and co-regulation, we always mean co-regulation, because co-regulation means a joint objective, a common objective, that is then pursued where then corporate actors see how they can comply to an objective, but an objective that matters to us as institution. And if a self-regulation exercise is about an objective that doesn't matter to us as institution, it's not in our radar screen at all. So as soon as it becomes in our radar screen and our attentional space, that means that by definition, I would say, or by construction, it is a co-regulation process. Otherwise, we wouldn't even know about it, in a sense. As soon as we have to know about it, to me, it becomes a co-regulation exercise, because at least the objective is shared. That doesn't mean that we intervene in how the stakeholders will arrange for compliance, but at least we have a stake in the goal. So that being said, of course, if the co-regulation processes end up with a code of conduct and the compliance and the repeat offense and all that will not be in the judiciary, in the tribunals, I think that we have to be very clear that there, what we play with is indeed reputation effect and reputation damage, and maybe fee if they want to make payments between actors, but it will not interfere with the judiciary as such. I think that to enter the judiciary, it has to come through another channel. Well, that's my vision at least, so that it draw on different resource from the public space, and really, which is, I say, mainly the reputation issue. And that's where transparency and monitoring by third party is important, because in a sense it produces punishment, but not judiciary punishment, another form of punishment. So we tap into the wider public space resources, and it does not substitute for what should be treated in the tribunal, in the courts. But we have to be, so for me, self and co-regulation should not, it's not a matter of externalizing law enforcement issues.
Questions? Go ahead, and please introduce yourself.
Thank you. So I'm Fabrizio Sestini. I'm a colleague of Nicole in DG Information Society. I just wanted to add more than a question, a comment. To start with from the issue of co-regulation, because I understand that what we have been talking about insofar, actually, it is truly co-regulation and not self-regulation, in the sense that we are trying to regulate the behavior of users. And if that was a real true self-regulation, the users themselves should regulate their activities. Now, this is, of course, an extreme point of view, but what I want to get is a link with a point that Nicole mentioned from the speech of Madame Cruz on one of the Internet Essentials, which talks about Internet must be pro-democracy. And so we must support the creation of bottom-up platforms for people to discuss and to communicate between themselves. And this is actually something that we are doing now. We are launching now an initiative which we call collective awareness platforms for social innovation and for social change. And this is something will be probably published in the next year to support, to fund, and then to support the emergence of bottom-up platforms for people to discuss based on the concepts of online social networks, based on co-production of knowledge, based on access to the environment, which will provide a means for people to get an extended awareness about what is going on in the world, what are the problems of the world, and what could be their behaviors in order to contribute to sustainability issues ranging from democracy, from health, from environment, and in a way then also be a help for a self-regulation, a real self-regulation coming from the users themselves. So this could be another perspective to tackle the issue.
Thank you. Sounds wonderful. Questions? Yeah, go ahead.
Yes, hello, my name is Kostas Rosoglu, working for BEUC, the European Consumer Organization. I was a bit surprised because the focus on self-regulation and co-regulation was presented as part of the corporate responsibility, but we've seen efforts on self-regulation and co-regulation directly affecting fundamental rights. And I was glad that the 2001 white paper on governance was mentioned, because one of the conclusions of the white paper is that self-regulation and co-regulation are great, but not when fundamental rights of citizens and consumers are affected. And I raise this because, especially when it comes to IPR enforcement, we've seen efforts by the European Commission to promote co-regulation and self-regulation. There have been a number of stakeholder dialogues trying to bypass the legal framework. I would just like to check with the representatives of the European Commission whether this is still the case, whether they still believe that self-regulation and co-regulation is not relevant when fundamental rights are affected. Thank you.
Yeah, lady in pink.
Thank you, Katarzyna Szymielewicz, Panoptykon Foundation, Poland. I would like to add my voice to this comment. I wanted to say exactly the same, referring to what the Commission said, that self-regulation is good as long as industry agrees that they are willing to endorse certain rules without going as far as to change the law. It's very important to remember that we cannot use that instrument if that affects fundamental rights. But I have another comment regarding notice and takedown reform, and what we heard, that the Commission is not reconsidering the general principles, rather looking into making that more precise. What we see in Poland, we see that especially courts have, they do struggle in interpreting the law. There is a lot of misconception or a lot of struggle about how to understand certain concepts. And I can give you certain examples. For example, hosting. How far the hosting, does it include certain services like Google search engine when there is a copy of a website being created? Is that hosting or is that not? Is this simply caching or mere conduit? So there are certain concepts that really are important to be clarified. Another example, the actual knowledge and how that impacts responsibilities. Certain courts in Poland understand that if an ISP monitors, for example, a forum and deletes offensive words, that's already complex monitoring, which would imply the knowledge of, for example, IPR infringements, which is, I would say, absurd interpretation, but we see things like that. Or another problem, which you kindly mentioned, that what kind of remedies users have if the content gets deleted in contradiction with the law. Do we only have civil measures like simple damages, which for a free of charge service is extremely difficult to claim? Or do we want to invent new remedies that will secure freedom of speech and secure users' rights versus certain powerful intermediaries? So there are numerous problems which I'm happy to refer to later, or I think we will have many opportunities to write them and send it to the Commission, which should be reconsidered, not only the structure of notice and takedown. Thank you.
Yes, on the first one, and also to mention that you ask for questions. It's not only questions, but it's comments and intake, because I have to say that this type of event is also where we get signals about what matters for stakeholders. So your point on fundamental right, let me reassure you that yes, of course, this remain. But I take your input as a need to remain cautious about that. And I want to just, again, insist on this articulation between self and co-regulation processes on the one hand and law on the other hand, is that, you know, I see that self and co-regulation is something to be tried out. In case it works, why then bother go through a law, which is, so it is, and as you know, it's more like, when we have to think about a measure, we go through a public consultation, we have impact assessment, and all this process leads sometimes to the change of projects, like we have seen in the e-commerce directive, that we moved from a revision to a communication, thanks to the public consultation. So self and co-regulation is only, there is not an active will to avoid regulation, it's just to be efficient and economical, if I may say so, with this process. And in fact, who will tell us if self and co-regulation work or not? Of course, it is the corporate actors who takes place in a trial of such a process, if they deliver or not. And then this is importance of the transparency as one of the good principles of such processes. If they do not convince that they will be efficient, and they, of course, then they are as if they did not exist. So it's only if they convince, and if the corporations taking part in it are accountable for what they promise, and what they promise is significant for the public opinion, that this exercise can be deemed to be are deemed to be successful. So I really think we have to engage with envisage self and co-regulation in a non-defensive way, because of all these transparency and third-party accountability measures. And really, I believe that if these are effective, it can really be a good way to engage the people who know best, maybe, what are the best means to achieve these objectives. So it may also open more effective way, in some cases, not all the time, of course.
It was probably unclear when I referred to self-regulation that we're happy as long as industry is happy with it. What I was actually saying was self-regulation is good as long as it helps us to achieve our policy objectives. And in a particular case, our policy objectives are the single market as well as the respect of the fundamental freedoms. It's an intrinsic part of the e-commerce directive. So that's what I was saying, yeah? As long as the regulator doesn't have to intervene because the public interest is already preserved, well, then I prefer self-regulation to regulation. That was my statement. Now, Some concepts may need clarification, you said, on the different types of services, on other types of language used in a directive. I would agree with you on that in an ideal world, we should indeed open up the directive and do some clarification here and there. However, the overwhelming assessment by consultees was that the risk of losing some of the fundamental principles that are in the directive would be bigger than the gains that can be obtained from clarifying a bit in the margins. Now, this clarification, to the extent that we can't do it by changing the directive, already takes place through court rulings. Of course, it's a piecemeal approach, but I think the court has already clarified a few things, and I mentioned them before, that provide much more guidance already for us than we had before those court rulings. And last but not least, even if we just look into the procedures, we can still, at that level, introduce some things that can help. If, for instance, a notice, in order for internet service provider to obtain actual knowledge, if it is clarified what the notice would have to look like, what quality criteria such a notice has to meet, that is already one step forward. If we clarify, for instance, that the person having provided that content needs to be consulted properly, that's a step forward. If we clarify what has to happen if legal content was taken down erroneously, so if we go through the entire process, we can already also at that level introduce lots of checks and balances that make that whole process more fair and more transparent, I think.
Hello, I'm Jeremy Zimmerman, co-founder and spokesperson of citizen advocacy group La Quadrature du Net. I'm just wondering how we could possibly protect such a fundamental right as the right to fair trial with self-regulation. We've all read the Sabam Scarlett decision, in which the ECJ forbids a court to order a generalized obligation of monitoring. Well, in practice, such a company as Google already put in place such a general monitoring on its YouTube service with the Content ID platform, which proactively, preventively scan every uploaded material in search for images belonging to some copyrighted material, therefore forbidding to publish parodies and other kind of fair use exceptions made out of those works through transformative works. So, in that context, I really don't see how guidelines on the current procedures could make the situation evolve in the right direction. I see that in Canada and I think in Japan is this procedure of notice and notice, where after being noticed, the operator sends a notice to the user himself, who can eventually reply. And if it doesn't, the content is taken down. But if he replies, then the case is taken to a court. And in my view, this is the only way to clear cases as complex as copyright infringement that very often require long procedure, long cases, expertise. And a company cannot have an incentive to do anything else than going to the most essential, simplest, technically and economically efficient procedure, that is a removal. And when they have the choice between removing the material or asking their legal service to assess the veracity of a claim or a notice, the choice is clear-cut.
Any more questions for this panel? Yeah, go ahead. I'm just going to look around because then we can round off afterwards. Yeah, 1, 2 more questions and then 3 more questions, then we'll finish this panel.
Hello, good afternoon. I'm Jean-Christophe Finidori. I'm an internet consultant specialized in internet governance. I don't represent any kind of stakeholders. And first of all, I have to say that this is my very first questions to EU officials. so be indulgent with me. My question is to the lady, I don't remember your name, I'm terribly sorry.
Mr. Wandre.
You've mentioned the multi-stakeholder models in different sectors, including the internet. But it seems that this model, this organization already exists. Is the ICANN since '98. This is a purely multi-stakeholder model, and it rules, if I can say that, the internet since '98, but previously through the IANA. My question is, do you want to create a European ICANN, or do you want to try to block the contract who deal the ICANN with the US government for the next 10 years? What's your positions about that, the ICANN and the multi-stakeholders to rule the internet? Thank you very much.
Erik Josefsson from the Green Group. I'm advisor on internet policies. I just wanted to connect to the question from Beuk regarding fundamental rights and self and co-regulation. It was mentioned in a 2001 paper, as I understood it. It's also the case that the 2003 interinstitutional agreement is actually precluding the Commission from supporting self- and co-regulatory mechanisms where fundamental rights, such as the right to freedom of expression, are at stake. Now, supporting is, of course, a word you can discuss. You can maybe assist or in other ways talk about self- and co-regulatory mechanisms. But are you considering in your work on this interinstitutional agreement from 2003? It becomes a very technical question, I know that, but it is the case that this agreement exists, and it precludes the Commission from supporting self-regulatory mechanisms in the cases where fundamental rights are involved. If you could just comment on that very shortly without becoming too technical. Thank you.
I don't have that much of a question, but a reply to comment. I can wait till the end to do reply and then comment back to the question.
Why don't you go ahead and say everything
Okay,
you want to
I'll
say
try
now?
to be as short as possible. One issue in general and one issue in particular. One issue in general, it's hard to find a company, I think, and I have concrete examples. I can also send you by emails, who is such a supporter of free speech and generally try to strike a balance between free speech and copyright enforcement. As concerns your example, every minute there are 48 hours of content uploaded on YouTube, which means there has to be some kind of software by which we can see, because there is no human who can actually monitor this. Google is somewhere in between copyright enforcement and the user. Of course, our concern is the user, and every time we have a solicitation in terms of getting something down from the internet, we make sure that we have something from a relevant authority. That's my comment. Thank you.
Okay, those were questions, and I'll give a final word to both panelists, and then we'll move to the next panel. You want a short comment? Okay, go ahead. Huh? A new question, okay.
Sorry, just one more question about do not track mechanism you mentioned. I would ask for clarification how the Commission, because we have so-called cookie directive that is sort of regulating the question of tracking, which poses a lot of controversies now and a lot of debate. So would the Commission rather go towards self-regulation in this area, or making existing regulation like the directive I mentioned more clear? You mentioned the do not track mechanism will be explored as self-regulation, while in the same time we have the directive which regulates that area somehow and the regulation poses a lot of controversies. So that's why I understand why there is more need for clarification, what exactly is required from the business. For example, does the business have to obtain prior consent from the user to serve a cookie? Personally, I would like to see more regulation here rather than self-regulation because of the controversies we see. But because you mentioned self-regulation, I would like to know exactly what's the Commission take on this. Thank you.
So first on the link between fair trial and self-regulation, I really, again, it comes to the articulation and what I call the complementarity between self-regulation exercise and lawmaking. I don't consider that for the moment, for example, self-regulation, I mean, self-regulation is an exercise, a structured exercise, so it's not what applies you know, between the norms or something like that. It is a structured exercise with a commitment at the end, a code of conduct or something that can be. So, of course, it will not, it should never prevent anybody from a fair trial, because fair trials are to be, taking place on the basis of law, and law exists. So where there is to be fair trial, there should be. And where there is self-regulation, it's a different form of check and balance of compliance. It's a different regime for me. So I really don't see self-regulation as a way to take away fair trials in any means. I mean, so I don't know if this answers your concern or not, but yes, and really self-regulations are structured exercise that has to be visible and cannot be considered as what is there when it's not formally a law or it is a practice happening. No, it has to be a structured exercise. Now, on the ICANN thing, no, the multi-stakeholder, well, Nelly Cruz expressed that she has concern with the way ICANN functions for the moment in several occasions, and indeed we think that more ICANN should take more into account preoccupations of Europeans and European member states. So there is a discussion there, but there is no willingness to do another ICANN or separate a European one, or not at all. There is a discussion. And the multi-stakeholder platform we mentioned would be to address issues beyond what ICANN is really is doing, or other issues of governance beyond what is dealt with within ICANN. Now, on the OBA, on online behavioral advertising, what is expected in the self-regulation exercise is to come up with something which is a proposal that would allow each of us to see very clearly, to make an easy choice, either by, you know, an easy button recognizable or something like that. So, and the circumstances in which it appears and when it's pop up and when it's tick and all that. The discussion is about that, but of course, the context will be established by the privacy legal framework. And you know that we are heading towards a proposal from the Commission on this issue in January, end of January. So the self-regulation will not substitute for this, and will be aligned and go beyond what is requested by this legal text. So there is no, the legal text will not, yes, self-regulation will be on top of this, that's what I mean, and not substitute for it.
And the interinstitutional agreement, could you answer that too? 2003 interinstitutional agreement.
Yeah, yeah, I'm sorry, your technical questions, no, was it, I didn't hear well,
So the 2003 interinstitutional agreement precludes the Commission from promoting self-regulatory mechanisms.
About fundamental rights, you mean? Yeah, yes, but this is
Fundamental rights, yes. As was commented by Böök, referring to an earlier paper from 2001.
But I can only repeat that the position of the Commission has not changed, and of course we do not recommend self-regulation where fundamental rights are at stake, so indeed. But if you are meaning that this is the case, please tell me where you think there is a self-regulation exercise which is putting fundamental rights in danger.
Well, that is the question, whether you have, how you assess that you respect the interinstitutional agreement in this area. If you do, how you consider, how do you process the issue that you're bound by an interinstitutional agreement, not to support self and co-regulatory mechanisms where fundamental rights are involved? That was the question. Just how do you deal with that interinstitutional agreement from 2003?
Well, you know, if you can help, on top of it, the fundamental right now are in the Charter of Fundamental Rights is in the treaty. So of course, self-regulation exercise cannot breach the treaty. So I don't see the point. But again, if you think that we are doing such a thing, please tell me.
Just on some of the other issues raised very briefly, La Quadrature du Net was referring to the general monitoring that players like Google would already be carrying out. Just to clarify from our point of view, looking at the e-commerce directive and the liability exemption, our starting point is that there is member states shall not impose the general obligation. The current legislation does not say that internet service providers are not allowed to do that. Yeah, so I mean it's a bit outside, which also sort of probably means that this piece of legislation certainly does not cover all these aspects you would want to see covered, but we live in a broader legal system where other checks and balances are in place, and that can be anything from competition law down to data protection law and many others. Yeah, so we are just dealing with one particular part of the puzzle, and we are trying to optimize its use in this game. You also mentioned notice and notice. This is precisely the sort of issues that we are screening right now. So when I said that we are going out now and see what is in place, what is being used, what systems are there, what are the advantages, what are the disadvantages, that is exactly what we are doing. And the next stage will then be to see, all right, is there anything that we feel confident enough to recommend? And then we come to the last stage will be about any legal or not legal instrument to achieve those objectives. Yeah? Normally, when you look into impact assessment guidelines of the Commission, you would then always have to look into no action or soft law or anything else, any type of law. And at that stage, we will then be confronted with any question, are certain options available in the first place, or as you said, if self-regulation is not an option where fundamental rights are concerned, well, that will then come into play at this stage. But we're at the moment at the stage of finding good practice out there that will help us reach our policy objectives.
All right, let me then thank the two first speakers very, very much for coming and answering the sometimes difficult questions. As we were talking, I decided to do a small poll on Twitter to see who should regulate internet. And so maybe we can do it here as well. So there's 4 options I'll propose first, and then you can take a vote. Who should regulate internet? The government, 1. The business community, 2. Both, 3. Or none, 4. So who should regulate internet? 1.
We should repeat your options.
Which is the government. 2 is the business community. Who votes for 2? Great. It's quite revealing. 3, both. And then 4, none. Okay, so on Twitter almost everybody said none. And perhaps our challenge today is to see where the balance is when we have to find one, and what are the appropriate. After the people from the Commission spoke, we've also learned that we're now not going to have any more PowerPoint presentations, so that's interesting. I'm going to ask you to have a short introduction, each of you, so that we can continue our discussion from your different perspectives quite quickly. So I'll start with Chris Adliff, who is the General Counsel for the Warner Group. This means he's responsible for all of the group's legal and business affairs activities outside of the US.
Thank you. Thank you very much for inviting me. I did actually have a PowerPoint, and then when I looked at it again, I thought it was so boring. I was so bored by it that I wouldn't inflict it on you. So there is no PowerPoint. I think one of the things that I hear said most often about the business that I represent, the music business, is that we don't need to really worry about what happens on the internet. We just need to fix our business model. That our business model is broken. If we could just fix the business model, everything would be fine. Well, I don't actually happen to think our business model is broken. I think the internet for us presents enormous opportunities, but it also presents significant challenges. For us, it's an amazing tool because it enables us to disseminate our music and our artists' music at a touch of a button, but at the same time, it enables other people who invest absolutely nothing in our business to profit from the wholesale theft of what our artists do. Our industry has changed, I think, further and faster than most any other business in the last 15 years in the digital economy. We were a business a few years ago whose revenue was derived almost entirely from selling pieces of plastic with holes in the middle, to one today where about a third of our revenues are generated digitally by the sale of music online. And when I bought the first record that I ever bought, which was back in 1974, which I know you'll find hard to believe, you could buy that as a piece of vinyl or you could buy that as a cassette. And today you can buy that same piece of music in about 200 different formats, most of them digital. The other thing I should say is I paid 75p for my first single record, and the price is about 75p today, 40 years later. There are about 400 licensed services around the world. I'm selling 15 million tracks, which is pretty much all of the music in the world. And of those services, 250 of them, approximately, are based in the EU. And the number of new services is growing all of the time. And those are services that enable you to download albums and singles in a matter of seconds, to be able to listen to all of the world's music on a monthly subscription for less than the price of a couple of cups of coffee. They will give you access effectively to a celestial jukebox of all of the world's music. 300 million people today own iPods. There are 10 million subscribers to Spotify, a service which wasn't even around 3 years ago. And that is one of the most innovative services I think you'll find on the market today. And I don't think those services would exist if we had really turned our back on the digital market, on technological developments. But the ability to grow our business and to help those digital startup businesses, which are mostly SMEs, by the way, those efforts are severely hampered by the pirate services. They undermine the commercial viability of everything we do. We estimate that today, still around 95% of all of the music that's being accessed online comes from illegal sources, and no business could ever tolerate that. But we really do know, though, that to beat piracy, you need carrots as well as sticks. We also know that carrots are better than sticks. But we believe that many people besides us have a role to play in helping a legal market on the internet to flourish. That obviously means ISPs as one of the players. We think if we identify a site which is clearly illegal, which has been set up for the sole purpose of making our intellectual property available online without any compensation to us or to our artists or to our writers, I don't think it's actually unreasonable to ask an ISP to block access to a website which exists totally for the purpose of making our music available illegally. The European Parliament agrees with us. Article 8.3 of the Copyright Directive requires member states to ensure that rights holders are in a position to apply for an injunction against intermediaries whose services are being used by a third party to infringe copyright. The courts of the member states agree with us, as recent decisions against Newsbin in the United Kingdom, and more particularly against the Pirate Bay in Italy, in Denmark, in Finland, and recently here in Belgium, have all shown. We think the search engines have a role to play as well. Yesterday, before I came over here, I did a search, actually it was on Google, where I typed in the words Plan B, that's one of our artists, and the word MP3. And of the first 20 search results that came up, 18 were for pirate websites. Only 2 were for legitimate websites. Then there are the credit card companies. The credit card companies are today making their services available to a lot of websites that actually look legal. They charge the consumer for access to content. The consumer pays in good faith. But actually what they're getting is a totally unauthorized copy of the work for which neither we nor our artists nor any of the original creators get paid. In the UK, we've worked with the credit card companies to stop providing credit card services to those sites. We need to see that happen more widely. Then there are the advertisers. A lot of these illegal sites have advertising on them. That's where they get a lot of their sources of revenue from. We'd like advertisers to work more closely with us to make sure that their products are not advertised on the sites that are offering our content illegally. In a number of countries, as you know, governments have introduced a series of escalating sanctions to alert consumers to illegal behavior online and to address web piracy. In most cases, all it really takes is one written warning to persuade people not to download music from sources they know that are illegal. And only in a very few cases do we think any further sanction would be necessary. And we don't think it's just for our benefit either. We already know that broadband providers manage their network traffic at times of peak demand. Peaks in large part by people downloading content illegally, particularly in the evenings. That's why often you'll find your broadband speed slow right down in the evenings. We also think that kind of program works. So in countries such as France and in Korea, where those kind of programs exist, sales of legitimate music now exceed those of illegal music, and piracy levels are significantly down by comparison to markets where those kind of programs don't exist. We also think ISPs have much to gain commercially by working with us, and we think that digital platforms can help them improve their offer to their own consumers. Partnerships already exist between Spotify and Virgin Media in the UK, with KPN in Holland, with Telia in Sweden. Deezer working with Orange in France. There are a number of these services all over Europe. And we think these are deals where everybody wins. We think the consumer gets a great and simple and reasonably low-priced service bundled with their broadband. The ISPs get a whole new revenue source, and our artists and our writers, more importantly, get paid for their creativity. In fact, the only losers in those deals are the internet pirates who get cut out of the loop for once. We expect to see a lot more of these services rolled out over the next year or two. So I think I'd like to sort of move the debate away from a them versus us and whose fault it is, whose responsibility it is, to a more cooperative commercial relationship that we can all benefit from. And I think just finally, just to touch on and come back to the sort of the issue of self-regulation. Well, yes, I also believe self-regulation and less regulatory and less legal intervention is a good thing where possible. I think voluntary arrangements tend to work better in cohesive, linguistically homogenous markets such as the United States. I think it's more difficult in a market of 27 individual member states. And here, I think, in the EU, I think we do need to see a coherent set of guiding principles towards a consistent approach without necessarily imposing specific solutions in any one market. Commissioner Barnier, I think, next year will be issuing his review of the enforcement directive. I hope that will enable us to have a clear framework from which we can all benefit, content owners, online businesses, and more particularly, ultimately, the consumer.
Thank you. I'm going to hold my questions. And now give the floor to Joe.
Thank you very much. The last thing that I was expecting from IFPI was a speech that pirates could sign up to. I think a lot of pirates would be perfectly happy with the concept of ineffective blocks being put in place that they can happily work around, and everyone can continue on as if nothing ever happened. So it's nice to see that it's not them and us. There's a certain rapprochement in approach, if not in philosophy, which is nice. I think we're suffering a little bit of lack of vocabulary when it comes to self-regulation, because there's a very wide spectrum of things that are called self-regulation, which are actually entirely different from each other. On the one hand, you have the development of HTML standards, where industry users get together to create a standard, and that's self-regulation. It works terribly well. It works terribly well because it's an internal process. Companies know what they need to do to manage their own services, to regulate themselves to be efficient. You also have entirely external processes that are also called self-regulation. So the illegal 3 strikes regime in Ireland, for example, is called self-regulation. It is policing of the customers in order to defend external interests. Entirely internal processes can be effectively self-regulated. Entirely external processes can't be effectively self-regulated. And the more external the process is, the less it is self-regulation and the less effective it's going to be. There are numerous myths, and thank you for already listing some of them, on which this self-regulation drive is based. So I'm going to quickly rush through 10 of them. The first one is that this self-regulation issue is a narrow European issue on a particular part of industry. In fact, there's a whole avalanche of outsourcing of policing online. There are measures from the European Commission, from the OECD, in the Trans-Pacific Partnership, and only last week, the bastion of democratic values, the Russian Federation, announced in WIPO that it wants to introduce more obligations on internet providers to police the internet. And the IFPI welcomed this measure from the Russian Federation. In other news from Russia last week, Reporters Without Borders issued severe criticism of the anti-democratic interferences in that country with online media. The second issue, which is also important, also in the IPR Enforcement Directive, is the idea that notice and action creates no jurisdictional issues. But if we look at what companies are expected to take action, the search engines, the payment providers, the advertising networks. Payment providers, the main ones, are American. The search engines are mainly American. And that means that this approach creates a very heavy risk of actually outsourcing our free speech and our democracy to American companies. And we see this already with apologies for picking on Google again. But if you make a complaint to Google under the US Digital Millennium Copyright Act, they de-index the content for the whole world, even though the complaint was under US law. The third myth is that ISPs are too evil to be trusted with copyright and so good that they can be trusted with freedom of speech. We've all heard going back for quite a long time that internet providers are parasites. They're getting rich on this so-called piracy that happens on the internet, and so this can't continue. So what we can do is we can put them in charge of freedom of speech, because they're so bad they can't be trusted with copyright, but they're so good they can be trusted with freedom of speech and democracy. One of those two statements, or possibly both of them, is not completely true. The fourth point is that intermediaries are in a perfectly balanced position to make rulings on illegality. There's this weird idea that today, tomorrow, and forevermore, internet intermediaries are perfectly placed to make fair and balanced decisions about what we're allowed to do online. In reality, and this is going to come as no surprise, businesses make decisions based on business priorities. So when the WikiLeaks case happened in the United States, senior politicians described WikiLeaks as a terrorist organization. And Visa, MasterCard, PayPal, Amazon, their internet domain name registrar, all withdrew services. Not because WikiLeaks had done something illegal. They weren't even accused of doing something illegal. They had their services removed because it was in a public relations benefit for those companies to take vigilante action against that organization at that moment. The fifth point is that intermediaries will be able to devote enough resources to policing all of us to avoid never-ending problems. In the UK, Yahoo, who even had a member of the board of the Internet Watch Foundation currently in place at the time, ended up having its photo sharing site, Flickr, blocked by several internet providers. How did the entire service end up being blocked? Because the Internet Watch Foundation said that one of the 51 million subscribers to Flickr had uploaded content that may be illegal. In Germany, the wonderfully named Gesellschaft zur Verfolgung von Urheberrechtsverletzungen, which is the Society for Prosecution of Copyright Infringement, persuaded Vimeo, the online video company, to delete 4 videos. This organization didn't own the videos. They had no rights related to the video. The videos were completely legal, but simply by making a complaint, they were able to take them down. The sixth point is an interesting one, in that copyright interests assume they can ask internet providers to do anything, and there's going to be no unintended consequences. IFPI, a few years ago, entered into an agreement with internet providers in Belgium to delete 10 internet news groups every week if IFPI said that they were illegal. So week after week, IFPI identified news groups, and the internet providers diligently deleted them. These lists appeared on the internet, and the pirates of Belgium rejoiced that IFPI had kindly identified the best places to find unauthorized music on the internet for them. Ultimately, IFPI got bored of providing a service broadly similar to the Pirate Bay and stopped doing it. A few weeks ago, the Belgian Anti-Piracy Federation went to court to demand that Telenet and Belgacom start blocking Pirate Bay. It attracted a little bit of publicity, not an awful lot. Within hours, depiratenbij.be was set up. So when the direct block was put in place, people went through the Belgian Pirate Bay to get to the real Pirate Bay. What was the result? The result was far more young people found out about the Pirate Bay. Far more young people laughed at a legal system that's obviously not fit for purpose, administered by judges who don't understand the internet, at the request of organizations that patently don't understand the internet. There's also a misunderstanding that there's no risk of unintended consequences for the online marketplace as a whole. We end up in a bizarre situation where the European Union is making very strong statements that there must be net neutrality, there must be search neutrality. Internet companies should not be allowed to interfere with traffic for their own business purposes. I agree completely. However, the European Commission is also saying internet providers must interfere with traffic for other people's interests. Well, that's not tenable, and one of those two priorities is going to have to give way. As mentioned earlier, there's a question mark over legality of so-called self-regulation measures. To give an example from earlier, what type of thing is breaching the 2003 interinstitutional agreement? In ACTA, which is being pushed heavily by the European Commission at the moment, there is an obligation on parties to support cooperative enforcement of civil and criminal law by the private sector. This is, for me, a black and white, obvious breach of an obligation not to support extrajudicial self-regulatory measures. The European Convention on Human Rights says that you can't infringe freedom of communication and privacy outside the rule of law. So does the Charter of Fundamental Rights. So does the International Covenant on Civil and Political Rights. I'm nearly finished. The ninth of the misunderstandings is that we can do all this without damaging Europe's interests. Well, China has the world's best online protectionism system. It protects its own market by informal arrangements with internet providers. We now have a situation that the European Union has taken the world's most effective online protectionism system and put it in a trade agreement, ACTA, and is trying to roll that out across the world. That makes no sense to our business interests. And the final point is that policymakers have reflected enough on this. They haven't. A classified document that's going to be published next year by an international economic organization has assessed that policymakers need to understand the role of intermediaries in economic processes when designing new rules about internet intermediaries. If policymakers don't understand yet the complex role of internet intermediaries, it's too early to make far-reaching policies that bring such major societal and economic risks. It is very difficult to understand why we're gambling the future of the democratic value of the internet. It's very difficult to understand why we're gambling the future of the economic value of the internet. And it's hard to understand how we have ended up in a situation where policy is being made based on guesses, half-truths, and just a few of the myths that I had time to go through today. Thank you.
Thank you. There will be some room for discussion, but first we will hear from Chris Smith, who is with ECSA. So go ahead.
Thank you very much. I'd just like to start by thanking Madam Schaake very kindly for inviting EXA and myself to attend this and to speak in this debate. As a composer and a songwriter, and thus as a stakeholder in the IP debate, I am pleased and honoured to speak on behalf of EXA, the European Composer and Songwriter Alliance. To tell you something of the organisation, its background, it was formed in 2007 and brought together composer organisations from 29 countries in 3 genre-focused pillars, representing pop music, concert music, and film and audiovisual music. Within EXA, I represent my own national organisation, BASCA, the British Academy of Songwriters, Composers and Authors, which itself has over 2,000 members, including such names as Sir Paul McCartney, Sir Peter Maxwell Davies, Elton John, David Arnold, and rather further down the scale of global recognition, myself. Within EXA, we recognise that there is a narrow and difficult path to be trod through the minefield that is the online environment. A balance needs to be struck, for example, between the need to protect children and the imposition of unacceptable levels of censorship and online scrutiny. Another such balance to be established is between the desire to provide ready access to information and intellectual property and the need to protect that same intellectual property and to ensure that its owner is properly remunerated for it. We wouldn't wish to pretend that finding these balanced positions is or will be easy, whether they're to be achieved by self-regulation or imposed legislation, but we do believe that any argument that defends one single principle, whether it be complete freedom of access to everything all the time, or draconian levels of governance, while denying any validity and opposing points of view, is frankly naive and simplistic. To argue, for example, that not being allowed to download my music for free somehow impinges upon an individual's human rights is rather like me saying that my human rights are being unacceptably regulated by not being allowed to enter your house and take your television. On the other hand, we also recognise that to seek to impose levels of regulation that would effectively criminalise children for downloading my song is ill-judged and practically unworkable. However, We do feel that ISPs must take some responsibility for the environment that they have created and from which they profit. An online portal where goods or services can be acquired is no more or less than a shop. And if any shop offered my goods for sale without employing basic levels of security, such as CCTV or a store detective, I would feel that it was being negligent in the care of duty that it owed me. Laws already exist in the world of physical commerce that could and probably should equally apply in the online environment. For example, the fact that it is illegal for children under a certain age to purchase alcohol is not going to stop many of those children from wanting to purchase alcohol, as I'm sure most of us remember only too well. Should we, in this context, make a criminal of the child who forges an ID and buys a bottle of beer, or should we rather enforce the existing legislation on the liquor store owner who persistently sells alcohol to children? Along with other rights-owning and rights-generating stakeholders, composers and songwriters have encountered at least as many challenges as they have opportunities thrown up by the explosive growth of the online digital marketplace. Not least of these is the alarming corresponding decline in the market for physical product. It's therefore becoming increasingly clear in the light of this shift in the market that if we are to make our way and survive economically as creators, we will have to do so in the online world. We are asked to exchange physical dollars for digital dimes, and yet even this exchange rate doesn't measure up when, for example, from my own experience, a piece of my own music performed online 537,420 times earned me the princely sum of 89 pence and generated such an enormous royalty statement that I was out of pocket by the time I'd printed it off. This is clearly not a sustainable state of affairs, and brings to mind a phrase that I heard quoted here yesterday and which I offer to you in closing. If art feeds the soul, who feeds the artist? Thank you.
Thank you very much. Now, would like to ask Malcolm Hutty to speak. He's Head of Public Affairs at the London Internet Exchange, Links.
I am. That's my day job, and they are who pay my salary. Although I was asked here as the president of Eurorispa, the
Sorry about that, my fault.
Eurorispa being the European level association representing the interests of the internet services providers across Europe through the national associations, of which Links is one. And I'm here as essentially representing the interests of the intermediaries, the internet intermediaries, whose job it is to sit between EDRI and FP. And it really does feel like that a lot of the time. But the title that we were asked to speak to went broader than music, broader than copyright. It was about policing the internet and self-regulation. And as intermediaries, we face many calls for dealing with objectionable content and behaviour, unlawful and illegal content and behaviour. And I wonder how many stakeholders that are directly interested in those other forms are here today. I wonder if we have any libel lawyers in the audience, any members of the counter-terrorist police, or police that specialise in racism and xenophobia generally. Do we have any financial services regulators in the audience? Or maybe gambling regulators and gaming commissioners? I wonder why I went directly from financial services to gambling. Tax inspectors as well, since we're talking about money. Child protection charities and child protection authorities. Regulators of medicines and medical products. Advertising standards authorities. I'm not going to go on forever. But there were an almost seemingly endless list of people that come to us with genuine grievances, genuine complaints about genuinely bad action, genuinely criminal content in many cases, or stuff that does infringe on other people's rights. So it's completely needs to be put aside any sense that, oh, well, we're just talking about something that's not really a problem here. if there was any sense of that. And if anybody thinks, oh, well, this is copyright, and actually, to be honest, the copyright industries, they're doing fine, so we don't have to need to worry about that, then I ask you to set that aside, because the issue is much broader. The issue is, what do we do about all this bad stuff? Coming now to self-regulation, we heard a couple of new self-regulatory initiatives that were mentioned. The forthcoming, the Do Not Track one, and further extensions to Safer Kids initiative. But the intermediaries that I represent are involved in a considerable number of existing self-regulatory initiatives that I think I do consider are self-regulatory. In particularly the child protection space, our members spend a lot of time and effort making sure that they are not part of the problem, to remove the material that is child pornography material from their own systems, to make sure that they are not hosting it. Setting up and funding, in many cases, hotlines for the rapid reporting of that material so that we can find out about it soon enough and get rid of it. A self-regulatory initiative. We have long had self-regulatory initiatives for the protection of our customers, alternative dispute resolution systems, for example, for resolving customer disputes. Certainly, underpinned by external regulation now in the telecoms package since the original telecoms package. But nonetheless, I would call it self-regulatory because it predated that, and because in most cases, the protections given by that go beyond what is required by law, because we want to regulate ourselves for the protection of our customers, so our customers are treated fairly. In another area, the security field, certs and public-private partnerships for security, again, being extended by the new telecoms package when it's and as it becomes implemented. But these partnerships and certs have existed for many years, and we work actively in them, fund them, support them, provide data and information sharing to support all of these things for the protection of our networks and for the protection of you all. Self-regulation at work. I won't go through them all, but actually I'll mention advertising being an example of something where it's not just our sector in the specialist area of our sector, but actually many businesses have self-regulatory initiatives in advertising standards, often complemented by external regulation. And new measures have been developed now, again being promoted or instigated possibly by the new telecoms package, but being taken well beyond that by the industry itself for transparency in traffic management techniques, so that customers are well informed about the traffic management techniques that internet networks operate. What draws this together? And I would describe each of these as being successful examples of self-regulation. And what draws it together? Well, in my view, self-regulation works and can really be called that when the ultimate decision as to what you do and how you do it lies with the body that is being regulated. Self-regulation is regulation of the self. So the ultimate decision on the actions that we take, the scope of them, the procedures that we follow, ultimately lies with us. Otherwise, it's not self-regulation, it's external regulation. There's a place for both. Now, that's not to say that we don't listen and consult as to what that should be, but ultimately the authority to decide how far we will go and when it's appropriate for us to act has to be ourselves, if it is reasonably to be called self-regulation. And this comes in and tends to lie when what I would call the 3 C's are in place: commitment, capability, and competence. Commitment, obvious. It has to be something, an area where we are willing to act, and to act where we can. Capability, though, is important. It has to be an area where we are actually capable of making an effective difference. Both in absolute technical terms, do we really have the technical capability to act? And also something that often goes unspoken but needs to be made explicit. Do we have the capability to act without causing such overarching harm to other interests, other legitimate interests, maybe the innocent third parties, maybe the very functioning of the internet, or maybe crucial other interests that are at stake? And if that isn't there, then the capability isn't there. And if the capability isn't there, then you wouldn't expect to get a self-regulatory initiative supported by the industry. And the last one is competence, which is really a question of legitimacy, authority. Are we really the right people to be doing this? And that's come up in the discussion already, and in some cases it is, and in some cases it is appropriate for us to be acting, and in some cases it's more questionable. In some cases it clearly goes beyond the core, and certainly in questions where, in issues where judicial processes and fundamental rights are closely invoked, then it does cause people to question whether we really have the competence to be making the decisions at stake. And it is easy to say that in all these cases, well, there's no fundamental right to engage in all these bad behaviours. There's no fundamental right to steal, as you mentioned a moment ago. Of course not. But there's the question of truth. Is it really true that that person was stealing? It's actually just an allegation. You say that he's stealing your content, but maybe he's got a license. Maybe it's his content. Maybe all sorts of things. We always have a tradition in Europe that before you are subject to serious sanction, there should be the right to be heard yourself, to make a defence for yourself, and to have a hearing before an independent, impartial party that is able to determine questions like the truth. When you've got two competing people saying, this is completely unjustified and illegal behaviour, and somebody else is saying, no, it's not, someone has to decide who's in the right. Is it really a case for self-regulatory bodies, for industry themselves, to take on themselves the function of that primary judicial function? Not always, I would say. Not always. And what we are seeing recently, relatively recently, is in Europe an increasing concern being raised about the way in which, the possibility that intermediaries have to take on that function, either, whether that be at their own behest, or more crucially, when they are called upon it by external regulation. And so we have seen a few new initiatives, a few new decisions that have come. Firstly, Article 138 of the Telecoms Package, for the first time, introduced regulation of member states by Europe, by the European Union, of member states to the extent to which member states can require, by external regulation, intermediaries, such as the companies that I speak for, to take away or infringe upon the ability of end users to access online services and information systems online, and put in place safeguards, that it be appropriate and proportionate and only where necessary, that there be appropriate procedural safeguards, and that they respect the European Convention on Human Rights and the Charter of Fundamental Rights and Fundamental Freedoms, that there be judicial protection and due process, that there be the right to a prior, fair and impartial hearing, including the right to be heard. These are new rights that have been granted to the citizen to protect against unwarranted external regulation of my members, but that impacts on the rights of third parties, of citizens. Another thing where the similar approach has been followed even more recently was in the Child Sexual Exploitation Directive, where there was an original proposal from the Commission that there should be mandatory blocking of paedophile websites or such measures, and that the European Parliament decided and supported by the Commission and by the Council, and it has become law, that instead blocking measures must be regulated, where blocking measures are that we would not go down the route of having a European blocking system, but what we would say, and what they did find important, was to regulate national blocking mechanisms. It's a minimal harmonisation directive, but nonetheless it does say that those blocking measures for the first time are subject to a minimum standard of regulation to ensure that transparent procedures are followed, adequate safeguards are provided, and that there is the possibility of judicial recourse for those who are blocked, that users are informed so that they're capable of having access to that judicial recourse, and that in any case the blocking should only be the minimum necessary, restricted to what's necessary and proportionate. So we're seeing the development here of a body of concern that we need to be not only regulating the internet, but regulating the regulation of the internet. And I think we're starting to see that to ensure a degree of balance. And the last new thing that I would mention is the Saban-Scarlett extended case, which we've heard spoken to before. And I won't speak to the various things that are said in there on fundamental rights. But there is one fundamental right that is mentioned there that might be overlooked by someone other than the spokesman for the commercial interests of intermediaries, and that's the fundamental right of the commercial interests of the intermediaries, that requiring ISPs, the court decided, to install complicated, costly, and permanent computer systems at their own expense in an attempt to protect somebody else's rights is itself an unwarranted infringement of the network provider's freedom to do business. And that is a fundamental right that is also protected by the Charter on Fundamental Rights and Freedoms. And that was part of the court ruling. So when considering what should be done and how this should be regulated, we need to respect and remember the rights of the citizens, the rights of the accused and those people, and such interests, alongside the very legitimate rights of property holders, of the responsible law enforcement agencies and so forth. And we also need to remember the rights of the intermediary too. We are responsible businesses. We have respect for the law and respect for property. We have respect for the rule of law and for fundamental rights. We also have responsibility in our own specific sphere to speak up for the protection of the internet itself and its capabilities and what it has to offer our society, and at this time of particular economic strain, speaking up for the protection of the economic development that is possible through the enormous innovation that the internet makes possible, is something that I feel that we have a responsibility to speak for too, to set alongside the very legitimate economic interests of what's actually a relatively discrete economic sector, the digital content industries. These things need to be balanced. Finally, we have one very particular responsibility to bring to the attention of policymakers. We, the operators of this telecommunications infrastructure, have a responsibility to keep it working. This is critical telecommunications infrastructure that now increasingly underpins our society, and that we have a responsibility to point out when the technical measures that are advocated by those that are not operators and do not necessarily understand the full implications of what might seem reasonable magic wand solutions would potentially have significant negative consequences for the reliability and capability of the information infrastructure. It's our responsibility to point that out to you, and I would respectfully suggest your responsibility to listen. Thank you.
Well, that responsibility has been taken, I think. We're here to do not much else. And now to listen to the last speaker, which is Jeremy Brooks, who after a career as which ended as a global managing partner with PricewaterhouseCoopers and a lot of experience in the field of transparency in the business community, is now in the role of independent chair of the Global Network Initiative, which is one of those multi-stakeholder initiatives that has been developed to look at respecting corporate global responsibility, as well as human rights issues on the internet. So please go ahead.
Well, thank you very much and good afternoon. I'm sorry you've had to listen for so long, but I'll try and make it as interesting as I can. We talked in the earlier part of the afternoon not only about self-regulation, but also about multi-stakeholder initiatives. We've now heard some very detailed comments, which I certainly benefited from, Malcolm, on aspects of self-regulation and also some of the newer legal decisions and findings which illustrate how complex many of the issues are that we're dealing with. And what the Global Network Initiative is itself a self-regulatory mechanism built up from a multi-stakeholder group of 4 constituencies. The 4 constituencies are the ICT companies themselves, the investors, mainly socially responsible investors, but not only. So those investors who are concerned about performance by the ICT industry. Then academics, some of them very insightful and doing long-term work on the significance of the internet, its implications both in society and from a technical point of view. And then the final group, very important for Global Network Initiative, the human rights and other civil society organizations. And these 4 groups came together really in response to a cry for help now nearly 4 years ago from the major ISPs operating in China, where they were being heavily criticized, particularly by the human rights organizations, for being active there and ignoring, in the view of the human rights civil society organizations, fundamental rights to freedom of expression and privacy of internet users. And out of that came a very deep debate which took place over about 2 years and resulted in a set of principles, the GNI principles, supported by implementation guidelines, so a set of guidance documents which the companies can use in striving for achieving the right level of upholding freedom of expression and the privacy of the users of their services, and finally a commitment both to say publicly what they're doing to comply with these principles, and something that we're now going through for the first time, which was called, I think, in the list of qualities which Nicole mentioned in the first half of the afternoon, monitoring. We call it independent assessment. It's currently being conducted by the founding members, Microsoft, Google, and Yahoo, with independent lawyers and auditors who are looking at their performance in the first round of independent assessment of their ability to put in place procedures and systems which will enable them to comply with the principles. An even more demanding stage will take place next year, which is that having signed off, hopefully, perhaps with some recommendations about improvements they can make, on their procedures and systems in place, the next stage will be, okay, let's now look at some specific cases and see how those cases have been dealt with and whether the systems and procedures in place have given the right kind of guidance and support for the companies to have taken the right kind of decisions, difficult though we all realize that they are. And we're going through a learning process in this assessment area. It's the first time that human rights for ICT companies have been assessed independently. And we've already come across some quite interesting issues, both of how do you assure the independence of a very large global organization being assessed by a very large global organization itself. So we're solving those particular problems. A more important one is a very perhaps American issue, which is that of legal privilege. And that will probably be a much more important issue for us to get our minds around and find solutions for when we come to look at individual cases where very frequently the legal department will have a very strong feeling of the need for control over that process, and therefore be rather restrictive in the amount of information that they will want to release to independent assessors. So I just give you that as a little bit of a feeling for how serious this process is. It's very innovative and it's unique in this particular industry, and it's a learning process. We're going to be reporting on the results of this first round of assessments in the spring of next year. By that time it will be complete. So watch this space. We're going to find it exciting, and we hope that it will be very interesting for all of those who are watching carefully this kind of multi-stakeholder self-regulatory mechanism. Perhaps just very quickly, two or three of the sort of fundamental ideas behind the Global Network Initiative. The first is the value of transparency. I mentioned that the companies themselves are required to state publicly what their positioning is, but it goes much further than that. It goes to transparency for the users, and an example would be where even in the very restrictive climate of China, Baidu, the Chinese ISP, has followed the examples from Microsoft and Google, and they actually mark when you want to access websites which are not allowed under Chinese law. They actually put up a notice, Baidu that is, puts up a notice under Chinese law, we can't show you this content. So that's a very minimal position, of course, and we work much further together with governments as an organization to try to obtain a greater readiness of governments to have less restrictions and to have less imposition of access to private data from users. So transparency is absolutely key. Another fundamental view would be that given the speed of change in the internet and the very difficult discussions, such as the discussions we've been having today, about the need for formal regulation of the internet, perhaps self-regulation is one way of keeping up with the quick changes that are taking place, because in the kind of environment of an organization like the Global Network Initiative, challenges can be discussed, resolution can be found, changes can be made, not that easily, but much more easily than through the political process, and particularly the political process with 27 states that we're coping with in the EU. So a call, if you like, for self-regulation in a very fast-moving environment, which is nimble of foot and better able to respond to the challenges of the changing technology and the changing marketplace. And perhaps finally, the recognition by GNI that self-regulation does certainly not replace due process and a very important role for formal regulation. And we heard many examples of that from our previous speaker, and much of that would be endorsed by GNI. What GNI is beginning to do, and of course that depends on the representativeness of GNI. Currently we have only 5 corporate members, about 50 members in total. So our membership from the investment community, which is growing quite fast, also from Europe, from the NGO community and from academia is stronger than the corporate community, but we have some very interesting discussions which are currently taking place mainly in Europe from potential members. Once we have a greater representative body from all of those constituencies, that will enable us to talk much more effectively on behalf of not just the ICT industry, but on behalf of society, because we represent the different interests which are in society through the constituents that we have. And one example where we've recently been active, and I know that's been of quite some concern also to many perhaps in this room, is on the Stop Online Piracy Act, and I'm sure that a couple of our speakers who represent the intellectual property interests of the music industry, would be very strongly in favor of many aspects of that act. In fact, GNI is, of course, fully recognizing the legitimate needs to protect those property rights, but at the same time has called to the attention of the US legislators, which are dealing with that particular act in Congress at the moment. They've called their attention to the danger of requiring proactive monitoring and policing of information of their users, and that this could be a dangerous precedent for many other countries. Rather than that just being a simple statement, it's amazing how quickly perhaps used comments in the West are picked up by more authoritarian regimes. It's amazing how when Cameron talked about the need to regulate the social networks after the riots in London, how that was immediately picked up in China and commented upon favorably. You see Western countries also need to regulate the internet in ways that they haven't yet done. So we're very concerned in GNI that the unintended consequences shouldn't move in that direction. I'll really stop at that point, but I would just like to mention one initiative that we're undertaking. We have been lucky enough to get some small funds to do some research, and that research is going to be on the balance points between freedom of expression and privacy on the one hand, and security and law enforcement on the other, recognizing that many of the government's concerns about security and law enforcement are legitimate. And so the question is, how do we find the right balance between the absolute freedom of expression and privacy needs on the one hand, and legitimate security and law enforcement needs of governments on the other? We've already held one multi-stakeholder meeting in London about 2 weeks ago. As the kickoff, we'll be having another meeting in January in the US, followed by a third meeting in March in India. This is then followed, is being followed by experts looking at this, digesting the input from the meetings, and then coming out, we hope, with some valuable insight, which again will give some guidance both to the GNI companies, but more generally to the ICT community, and obviously we'll be more than delighted to share that both with governments and all interested parties. So thank you.
Thank you, and thank you all, and thank you for being such a patient audience. Let me look around and see who has any questions. I'm going to take 3 at a time, and I'm going to ask everyone to introduce themselves. So 1, 2. All right. We'll start with these two over here. Go ahead.
Yes, hello. For European digital rights, I have a question for Mr. Ancliffe. Since you stated that piracy is a severe threat to your business, I was wondering, according to your annual reports, in 2001, the revenue of Warner Music Group was $3.2 million, and in 2008, $3.5 million. So I don't quite understand your concern. If you could tell him.
And last year it was about 2.2, so you can pick whichever points in time you like. I mean, the recorded music business 10 years ago was worth about $30 billion. Last year it was worth about $17 billion. There is no doubt that our business has been materially impacted by piracy. I mean, I think it's it's very easy to have a go at big business. We're not even a particularly big business. I think we think of ourselves as an SME. But I think what do you have to well, a big SME. But what I think you have to remember is that creativity is something which Europe does incredibly well, better than I think most other regions of the world. The creative economy in Europe last year represented about 7% of GDP. It employs about 14 million people in Europe. These are people's jobs. I mean, we think of it in terms of big business, but actually it really is about the jobs of millions of people and the livelihoods of millions of artists and writers.
Thank you. Yes, the line is indeed between self-regulation and compliance or liability. When I mean compliance, in the condition for good practice is compliance to the code of conduct adopted, but I think that indeed self-regulation shouldn't be seen as a way to subtract some area from or creating a black box of automatic liability or compliance things on other things. So really when I meant compliance, doesn't mean compliance with the regulatory framework as it is. This of course remains fully in the scope of the judiciary and the courts. So I really take from what I heard that indeed the liability thing is not an object of self-regulation per se, but should really be different, distinct, and have their own objective. Now my question then to Jeremy would be, can you tell me the extent to which you fix what are the objectives of the self-regulation exercise? Do you are they clearly spelled out, or is it more a sort of thinking what's good behavior, what should we do, or so? Yes, to what extent do you really clearly identify the objective you're striving for at the beginning of the exercise?
Well, thank you. I should have brought that out more clearly in my quick introduction. The objectives at the high level are to enable the ICT industry to uphold and promote freedom of expression and privacy for users on the basis that these two human rights will form the basis for the most creative development of the internet for the benefit of all. So at the high level, that is its objective. Clearly, there are sub-aims, and I think I probably brought that out more clearly by saying that the purpose of the formulation of the principles, and particularly of the implementation guidelines and of the whole assessment process, is to enable companies to learn exactly what that means in practice. How do they implement these nice-sounding principles, and how do they then deal with government imposition of rules which may or may not be in line with international human rights standards? So that is, in a nutshell, what the GNI is trying to achieve.
Jeremy Zimmerman, again, La Quadrature du Net. I'm more and more disturbed by hearing this term self-regulation, where I more and more hear the term privatized regulation or privatized enforcement. And I'm especially worried when the music industry represented here kept blurring the lines along the years between what is for-profit copyright infringement and not for-profit copyright infringement. In that context, I wonder how proportionality of measures to be taken can be assessed. So after combating non-for-profit sharing between individuals through peer-to-peer networks, you have created those massive mafia-like websites hosted outside of the EU that are distributing in a centralized manner streaming or direct download and make a profit out of it. So you will step further, request the filtering, the blocking of this website, and inevitably, as Joe pointed out, it will fail. So you will go one step further and require filtering to be automated and constantly updated, or deep packet inspection technology be deployed and things like this. And this escalation, to me, is something extremely problematic, as the measures are, it's not self-regulation, it is imposed. It is imposed through political process. It is imposed through ACTA. It may be imposed through the revision of the IPRED directive. So it is not just spontaneous, it is indeed imposed. But the measures we are taking, the so-called, the harmless sounding cooperation we see everywhere in ACTA, OECD, G8, IPR, guidelines of Mr. Barnier and so on, and those measures are programmable machines that we will program to do enforcement. We will program machines to detect whether some behavior or some content is alleged legal or not, and we'll program machines to block it or block access to it, automatically remove it. Well, these kind of measures is exactly what most of us agree should be combated when operators do it for commercial purposes, breaking net neutrality, because it harms business, competition, and free speech, and it harms the next startup that you will buy out to pretend that you invent business models and that your previous business models are not flawed. So these are exactly the same measures that operators use to combat competitions, and these are also exactly the same measures that are taken in authoritarian regime to censor the internet for political purposes. So I'm very much worried here, and I hope that the EU legislator will mostly frame this kind of behaviors rather than encourage them through the so-called easy wording of self-regulation.
I'm not sure I quite recognize the sort of the apocalyptic view of the world that you think we're proposing. I mean, we've always been very clear. We want to act within the law. We're not trying to do something outside of the law. What we are trying to put in place are reasonable frameworks. We're not trying to infringe people's fundamental human rights. We are simply trying to protect creativity in Europe by reasonable means. I just don't recognize the future vision of the world that I think you're proposing.
You should read ACTA in more details then.
Yeah, do you both want to come in? Okay, yeah, Joe first. Yeah, go ahead.
Yeah, I think ACTA is worth considering because it's quite a good case study. There's a lot of meaning in a small amount of text because it talks about enforcement, similar civil and criminal enforcement by private companies. And there's some of the oddest language I've ever seen. It says, with due respect for the fundamental principle of due process. There is no fundamental principle of due process in fair process in international law. So ACTA creates something that sounds nice, fair process, to replace the words due process. And I'm really happy to hear Mr. Antcliffe saying that he wants to respect the fundamental rights of consumers. Because if we don't want, in the OECD and in ACTA, references to fair process, where it should say due process, if you also support replacing all references in such international texts to refer to due process, then we can go to our government and say, IFPI and EDRI agree completely, due process down the line, and that would be fantastic.
I completely agree that it is a question of proportionality. What we mustn't do in regulating things is to turn copyright into a concept that is in itself vilified, because then we shoot ourselves in the foot. Having said that, what would seem to be very innocent in itself, the concept of peer-to-peer sharing and friends passing things around, becomes a drip effect which cumulatively eventually has a very significant economic impact upon IP rights holders. And so the very fact that it's an individual to an individual around the world doesn't really make the difference when it comes down to the impact that it has upon the cumulative effect of sales.
Okay, I'm going to actually say a little bit about that, because it's very tempting to now start talk about copyright and whether or not piracy may decrease or increase economic benefits or creativity for that matter. But what I want to try is to go back to some of these fundamental principles, because a lot of people have mentioned fundamental rights. And I learned something new, because I didn't know that the right to pursue business or do business was a fundamental right. But it also strikes me that then others are free to do so, and then we get competition, and it's something that in general as a liberal I like very much, and I don't believe in over-regulation at all. But I do recognize that the fundamental right to life, for example, is a different one than the fundamental right to do business as a conceptual matter. I'm not trying to say any one of you is trying to infringe on the right to life, but just to acknowledge that there is a hierarchy of rights. And it's not only me who thinks this, but it seems that this recent European Court of Justice ruling has actually quite clearly established that whether or not people have copyrights which are a right in and of themselves, that the ways in which those are sought to be enforced have limits. And I think that that is where the discussion here sometimes gets blurred a little bit, or where the arguments get blurred, that even when there can be a right on the one hand, or an objective on the one hand, that the means in which to accomplish those can have collateral damage and can pose a challenge to other rights, I guess. So I would be interested to see what you all think of this ruling of the European Court of Justice, because a lot of people have actually considered it as quite a game changer for this whole discussion. And perhaps it can also give some closure about what rights prevail and what methods are appropriate and are inappropriate in Europe. So maybe that would be something to discuss. And then I'm going to also, in the meantime, look around for questions. So I don't know if any of the panel wants to respond to this. Malcolm?
Yes, I'll say a little about the right to do business that is protected. Not obviously, it's not protected by the ECHR, as far as I'm aware, but by the Charter of Fundamental Rights and Freedoms. It's my understanding. I'm not a lawyer on this, I must say, but I think if you think about it, it's not so surprising. If you think about what the right that is actually being protected there, because the court was balancing legitimate interests on two sides in the Sabam Scarlett Alexander case. There was the property right in copyright, or some people, what's called legally a property right in copyright, on the one hand, and there was the business of the network provider that was being asked to expend large amounts of money in complicated and uncertain systems on a permanent basis for the benefit of some other party. And I don't think it is that surprising that fundamental rights should protect my right not to have to subsidize his business just because he wants me to. Now, we can be sympathetic to the harm that is done by intellectual property right infringement to the recorded entertainment industries. And I'm not going to get on board with those that say, oh, well, there's no harm, they're making a fine profit. I recognize that infringement does cost you some money, but we have rights too. We are rights holders. We are all rights holders. We all have the right to engage in trade. That's one of the founding principles of the European Union. But to engage in communication, to receive and impart information, and to do the things that allow us to do that, which includes running networks to support systems that do that, and not to have, and in a sense, the right that was being protected there was both a particular commercial expression of the right of freedom of expression to be able to engage ourselves, and also, at the same time, a sort of particular commercial expression of the right to property, that our property shouldn't be taken and used for his purposes. You know? And so there is that balance to be struck, and there is a question of proportionality in this. There is a balancing of interests that the courts ought to strike. But they did feel that there does come a point where you're just saying, well, just because you're the internet intermediary doesn't mean that you are just a tool of somebody else's commercial interests, and that fundamental rights will protect against that and will enforce that. No, there comes a point where you have to say, no, that's not fair anymore.
You think that point
Well,
is...
I think Malcolm is right. It was a question about proportionality. But the case did still underline the essentials of Article 8.3 of the Copyright Directive, which is that intermediaries do have an obligation in the member states to ensure that rights holders are in a position to apply for injunctions. That was upheld. Nothing has changed on that. It simply said that the measures in that particular case that the court at the lower instance in Belgium applied were too wide. But the fundamental obligation is still there.
But just a follow-up question of what Malcolm said also in this context, do you think the point of disproportionality has been reached now, that there is too much push for internet service providers to pick up the tab?
Clearly found in that case that it had, and we are clearly going to have a discussion going forward about the extent to which this was just a narrow case and couldn't possibly be read any broader than in that one very specific set of circumstances, or on the other hand, what's actually quite a wide-ranging ruling that's written in really quite general and overarching terms that sets out standards by which we can judge not only this one particular case, but also future measures that are adopted. So they didn't just say, in this particular case you've gone too far, but it actually set out a standard that could be applied of and the wording was, I think, a complicated, costly and permanent computer system at its own expense was, I think, the operative wording. Now, that is a standard that it said would result in serious infringement of the fundamental right to do business. And that sets out a new legal standard. And we will have, the lawyers will go to town on this for a long time, I'm sure. But I wouldn't say that this case is one which is just unique to its own particular circumstances. There were basic principles being considered by the European Court for the first time, and it chose to set out a judgment in what are quite broad terms, clearly to identify that there are serious interests on the other side that's not all about Article 8.3 of the Copyright Directive, it's about other things too.
Yeah, and I think that the cost aspect is one, but the process aspect is another one, not just due process, but also time process. Because recently I asked a small country telco how many requests from the content industry they got for blocking or taking down sites. I don't know if anyone's interested in taking a wild guess, but it sort of blew my mind since we're doing polls today anyway. Does anyone want to guess? Small country, the telco, how many requests from only content side to take down sites? 20,000 a week. And so dealing with those requests or sifting through them already takes time. So I also think that whether or not we want to call it regulation, whether we want to talk about what the government should do and what business community should do, that we should look at processes that are manageable and that there's not an incentive by some to obstruct the tubes or the system to an extent that that would be a benefit in and of itself or that it would stagnate the business of others. So that was just a side note. And I'm also interested in general about the costs of enforcement. What if it leans in the public sphere and is in the hands of government, and what is taken up by private businesses? Because I've also heard examples, for example, from France, about the costs of Hadopi enforcement and also the benefits that it brought, and it seems to be quite disproportionate. But I don't know, perhaps others have some thoughts. I'm just going to look around the room, see if there's any more questions or whether we should conclude. Maybe I'm not seeing it.
To the left.
Okay, sorry, yeah, you're behind the camera a little bit. Go ahead.
Just one question. Among the envisaged actions described by the music industry representative was contacting payment service providers and ad operators in order to block the financing or the service providing to sites, to illegal sites. Since I didn't hear any mention to the word court, Are we talking about sites which the music industry considers illegal, or sites that have been deemed illegal by a court? Because in the latter, in the first case, I think if that's not operating outside the law, I don't know what is. I mean, just blocking the financing of a site which you and you alone consider illegal. Just clarification.
In the examples that we gave to those to the credit card companies, there were two sites both operating out of Russia. All of those sites had on them was our music, nothing else. They didn't do anything else. Those websites, they simply made our music available. There is just no justification for making our music available without any license from us whatsoever. We know we didn't give it a license. We know all our music was available on there. We didn't think it was unreasonable to say to the credit card companies, this site is illegal. We'd like you not to take payments from it.
And did they?
In the case of the UK credit card companies, yes, they stopped processing payments from those sites.
I'd like to also say something about this, that it is very easy, and big record companies and large businesses are an easy target. But behind them also, the content is delivered on the whole by small individuals. The average composer, I think, in the UK earns under £5,000 a year. We're not actually talking about just major pop stars and huge corporations. We're talking about hundreds and thousands of people who struggle very hard to make a quite small living. And those people are indeed all materially disadvantaged by a climate which allows people to take their content for free and feel that it's okay to do so.
Well, just a small response to that, because I care deeply about arts and creation. I think it's a pillar of open society, but I truly question, and that's something for a different discussion, which we'll surely have, what are the best ways to really make sure that artists get a fair remuneration? And I believe it's debatable whether enforcement will cause that, or whether we need more drastic reforms of copyright laws in general. But that's really for a different discussion. But I just felt like I want to emphasize how important I think it is that people who create get a fair remuneration. But I think sometimes the discussion is so distorted that even if there would be many, many more measures to battle this climate, that we're looking in a tunnel instead of zooming out and looking at the bigger picture. But now Joe wants to come in.
Thank you. The poor artist argument is compelling, but I think we glad you agree.
Very compelling.
We have to stop educating the world that copyright is, as Commissioner Cruz said, and you said you feared, copyright is a ridiculous thing. The exceptions and limitations regime in Europe is completely unworkable, yet the content industry stops progress. What does the exceptions and limitations regime mean for European citizens? It means that when esteemed academic Richard Stallman uploaded a video onto YouTube with a clip of music, which was completely fair use and not a separate exploitation of the work, when he put that on YouTube, it was left online by YouTube in the United States. In Europe, the owner of the work complained to YouTube saying, well, the exceptions and limitations regime here is confused, unclear, it's probably illegal in most European countries. So Google just blocked access to that entirely legal, unexploitative video for everybody in Europe. That makes people think copyright is an ass. Licensing from one country to the next is extremely difficult in Europe. The amount of money that Spotify's lawyers must make defies belief, because we've got a ridiculous system that's preventing legitimate content getting to consumers. It makes the legal system look like an ass, and this legal system is being defended by the copyright industry. Term extension, the greatest donkey of them all. Yes, if there are starving artists, why on earth did we spend years getting term extension in place in order to benefit the richest artists in Europe and more particularly in the United States, and feed the coffers of the starving Warner Group and friends? Sorry, that's an SME, I forgot.
Anyone else? Okay, oh, yes, go ahead.
I'm Leena Roppainen from Electronic Frontier Finland, and I just wanted to bring out the point that a lot of people, at least in my age group, we also copied tapes when we were young, and then when we grew older and started making more money, we started buying more content, and I fear that if the content industry keeps on sticking with their sticks and making itself look like a very bad guy in all these messes, you're not going to lose only the current generation. You will keep the future generations also away from becoming legal buyers.
I mean, I was very open with you at the beginning. We don't think it is just about sticks. We know it's about carrots. We know we have to create services that people want to use and also to pay for. There are 250 of them in Europe alone. You can obtain all of the world's music for a tiny amount of money a month. In fact, on some of the services, because they're ad-funded, you as the consumer don't have to pay anything at all. So I think it's unfair to say that we just stuck our head in the sand and completely ignored the consumer and we've just reverted to the sticks. I don't think we have at all. I think we probably license our content more than any other business that I can think of. And I can't think of many businesses that have moved to over a third of its revenues in under 10 years coming from online, from having been completely physical.
Just to add that in the Netherlands, some creators and consumer organizations did feel that there was a tendency to criminalize audiences. No fingers pointed, but there was a tendency for that, and that was proactively refuted, or people just didn't think that was useful and then started to come up with their own sort of bottom-up proposals. So I think the concept of who is criminalizing, who is policing, who remains very relevant, and where the incentives are for both change or for regulation or for pushing to regulation is fascinating. But Malcolm, you want to come in?
I just wanted to say very briefly, because I think there's a danger of a rat hole here about the rights and wrongs and the merits and demerits of the recorded entertainment industries and how important they are and how much they're being harmed and so forth. That it's most helpful to avoid, because there's a bigger issue here. I mean, we've all got sympathies with the situation, or at least I've got sympathies with the situation that they face, and we also have frustrations. Many of my members would like to do more business in promoting digital content legally and find it very difficult to deal with some of the things that were just complained about. So I understand that, but there is a bigger issue here. I opened my remarks by listing a great number of people that are interested in policing unlawful and illegal content and behaviour online that goes well beyond the narrow interests of the recorded entertainment industries and goes well beyond questions about whether or not they're a sympathetic complainant. You know, we can't, terrorism, child protection, racism and xenophobia, these medicines that are being sold that will kill people, these things matter, but do we really want to ask intermediaries to decide whether or not a particular thing that is complained of falls into that category when having accepted that that category absolutely must be defended and action must be taken against it when it is true? Yeah? Or do we want to build a society where we have one rule offline based around standard and long-established procedures and respect for basic rights and basic procedures and independent judgments, and online, a society where actually, because you've got an intermediary, you don't need any of that? I believe that the law should apply online as it should offline. I believe that the rule of law should apply online as it should offline. And then when any of these list of people, including the rights holders, but not exclusively, including people that are actually maybe much more sympathetic to some of you that are critics of the recorded entertainment industries, when any of these people come to internet intermediaries, there are times when we do have to say, even without a court process, it's so urgent and the interest at stake is so severe that we must take action first. but we should start to define when those circumstances are and narrow them down very carefully, because otherwise we will find that the rule of law does not apply online, because we are just simply taking orders from anyone that claims harm is done. And that is a very dangerous place for a society to be put. And my members, as the intermediaries, don't really want to be facilitating that.
I think that's very well said and very true. Let me look around for a last round, or otherwise I'm going to thank you all for being here, especially the panelists, for engaging in what's not always an easy discussion. It was probably not the last time that we have to have this discussion, so I also want to welcome everyone to continue sending suggestions and engaging with each other, finding each other to try to find solutions instead of addressing the problem. So thanks.